Honourable Paul Green.
Mr Assistant President, I rise on behalf of the Christian Democratic Party to speak on the Assisted Reproductive Technology Amendment Bill 2016, and the aim of the bill is to allow persons who were born from assisted reproductive technology treatment using donor gamete prior to 2010 to obtain non-identifying information about their donor and require ART providers to retain records for 75 years. It also creates a new offence for the destruction or falsification of any ART records, and of course replaces the 5 women limit to the 5 family limit. It also acknowledges that increase in the maximum storage limit for donated gametes from 10 to 15 years, and allows participants in a private ART arrangement to include information on the central register accessible by children born from such arrangements, as well as allows an option for parents to include a declaration, that is, an addendum to a birth certificate that a child was donor conceived. We'll briefly run through some of the amendments and comment. The first amendment allows person born from assisted reproductive technology treatment to prior to January 2010 the right to obtain non-identifying information about the donor, such as the ethnicity of and physical characteristics of the donor, the relative medical history of the donor, and of course the sex and year of each offspring of the donor. This is an important amendment and allows individuals to discover who they are without compromising the anonymity of the donor. Everyone has a right to know who they are, Mr Assistant President, where they are from, and what may medically affect them into the future. A donor conceived constituent wrote to my colleague, yourself, Mr Assistant President, and wrote, this is really important to me. We need to know our medical history, and we need to know our genetic relatives, our culture, our history, our language, what our great-great-grandparents did during their lifetime. This is about family, but perhaps not in the way many people might assume. We love our dads, but our lives are made even richer through knowing our donors' heritage. The Christian Democratic Party supports the view to obtain non-identifying information about the donor, and believes it strikes a balance between the interests of the donor conceived people and also the confidentiality of the donors. The bill also creates a new offence relating to the destruction or falsifying of any ART records, and raises the limit for bringing procedures for breaches of the Acts from 6 months to 2 years. I asked the government, Mr Assistant President, how many people were prosecuted for such breaches. I believe not many, if any. I see a problem here. The fact is, we probably do not know if a record has been tampered with or destroyed until a donor-conceived person tries to receive such information and it's not there. I'd imagine this would be well after 2 years and probably too late to prosecute. The New South Wales Government advised they does not support allowing pre-2010 donor-conceived individuals to access information on the Central Register, including identified information about the donor without consent. The Parliament Committee on Law and Safety did not recommend this path. Alternatively, the committee recommended a consent-based model where pre-2010 donor-conceived individuals should have the right to de-identified information regardless of consent, but identified information should only be disclosed with the consent of those donors. In saying this, the government does not support Labor's amendments. The CDP have examined this closely and is keen to move towards centralised record base. However, it is also needs to be recognised that in the past many donated on the basis of confidentiality. The government advised the centralisation of records is estimated to be in excess of about $2 million, and ART providers noted that there would be a large cost associated with providing all their pre-2010 records regarding births resulting from ART to health. The cost arise because the ART providers would need to retrieve their pre-2010 ART records from storage, review each file to determine if the ART treatment involved donor conception, copy each file that related to donor conception and send it to send the files to the Ministry. The Christian Democratic Party will move amendments to this bill and accelerated statutory review within 12 months to consider how effectively the de-identified records are being accessed and to consider the business case for centralising of records. The government has stated they will not, no matter the result of the statutory review, consider the releasing of pre-2010 identifying information via retrospective legislation. The reason that the case with the fact that many pre-2010 records hold little to no information on donors. Also, there was no previous obligation to keep the records for an extended period. Once again, Mr. Assistant President, a constituent stated in emails to us, all we want is the truth. Adoptees lobbied for retrospective access to their birth records and the sky didn't fall in when that was granted nearly 40 years ago. DC people, or donor conceived people, want the same thing with contact vetoes in place if the donor conceived people or donors don't wish to direct contact. The Christian Democratic Party aims to address this concern by our amendment to a statutory review within 12 months to assess the case for a centralised record system. I note, Mr. Assistant President, we are very strong about a centralised record system, but we accept that it would take some resource to put in place, and we've asked the government to come back with those facts and figures, and of course that would probably be within that 12-month statutory review of how we could pursue that. This bill creates a new section 22A which allows a birth registration statement to include a declaration that a child was a donor-conceived person. If such a statement is made, the Births, Deaths and Marriages issues a birth certificate to a person over the age of 18 years with an addendum stating further information may be available from the central register established under the ART Act. The birth certificate itself will not include any information that indicates that person was donor conceived. A constituent once again advised that they were concerned, stating, quote, birth, death and marriages will continue to issue birth certificates that are an outright lie, she goes on to say. She continues, I'm lucky that my parents told me the truth, but estimates are there are 60,000 donor-conceived people in Australia, and research has shown that that's just 10% of us. That 10% of us are told the truth. So that is a lot of people walking around the community being issued with a false identity. Unquote. The Christian Democratic Party understands that this remains a sensitive issue for donor-conceived people. However, an addendum allows the parents to tell their offspring in their own time about such issue. It would be advantageous for the government to assess the success of such birth certificates in their statutory review. The ART is likely to cause disagreement and disputes between people with different views. However, as the Minister said in the other place, the bill aims to strike a fair balance between the different and sometimes competing interests of donor-conceived individuals and women undergoing ART treatment and donors. Mr. Assistant President, I heard all the previous speakers, and I can't vouch enough, is that for a lot of these people, at the beginning, obviously for us, for those that are unable to have children and this assists them to have them, we can never underestimate that there is an innate being in our souls to know where we're from and who we're from. And this bill goes somewhat, a little way, to address some of the very, very sensitive issues that are coming our way very quickly, given the way that we're starting to look at the family structures. So the Christian Democratic Party looks forward to the results of the statutory review and commends the bill to the House.